welcome to the explainer. Okay, let's just dive right into it. If you've ever filled out onboarding paperwork for a new job, you know exactly what I'm talking about. That little knot of anxiety when you hit the background check section. Today, we're unpacking all that intimidating legal jargon surrounding employment background checks, what you're actually legally required to disclose, and what, realistically constitutes a fireable offense. We're going to break down exactly how courts view these disclosures and what protections actually exist for us as employees.
So, I want you to imagine this scenario for a second. Imagine the absolute sheer panic of checking no on your HR verification roll when they ask if you've ever been involved in a criminal case. You check no because, well, as far as you know, it's the 100% truth. You get the job, you settle in, and then months, maybe even years down the line, you are suddenly fired. Why? Because the background check dug up a criminal charge you literally never even knew existed. So is that legally fair? Can an employer actually terminate you for failing to disclose a total ghost from your past, one you couldn't possibly have known about?
To answer that, let's zoom in on a really high-stakes 2026 case out of the Orissa High Court. It's called State of Odisha versus Sagarika Parida. And this case just perfectly captures that massive tension between an employer's right to vet their staff and an employee's right to basic fairness. So here's the deal. Sagarika applied for a public job, filled out her verification roll, and explicitly stated, "No, I have never been accused in a criminal case." The authorities ran her background, they found undisclosed cases, and bam, they fired her for making a false statement. But Sagarika didn't just take it. She fought back, taking this all the way to the High Court. When we look at the timeline, you can really see how this whole thing builds, because the dates here are absolutely crucial. On August 4th, 2017, Sagarika was officially acquitted in a criminal case. But, and this is a huge but, that acquittal was recorded in her absence. She literally wasn't even there. Then, just weeks later on August 21st, she files her verification roll for the new job, honestly checking no on the criminal history part. Sometime post-2017, the state spots this so-called discrepancy and issues a termination order. She ends up battling this in the legal system for years, which finally culminates in a 2026 High Court decision ordering her complete reinstatement.
Now, what's really fascinating here is the intense friction between the two sides. I mean, on one hand, you've got the employer, the state in this case, and look, their argument makes total sense, right? They represent a disciplined organization that demands strict moral standards. To them, any suppression of facts just looks like deceit. It looks like a calculated lie. But on the flip side, you have the employee's reality. Sagarika was completely in the dark about these cases. It was a genuine good faith mistake. And to top it all off, she was actually acquitted of all charges anyway. So it's this massive clash between rigid institutional policy and, well, messy human reality.
Ultimately, the division bench of the High Court sided with Sagarika, and Chief Justice Harish Tandon gave this quote that brilliantly illustrates the middle ground the court landed on. He said, "Suppression of material information should not be of a trivial or a technical nature." Basically, the court was saying, sure, background checks are absolutely vital, but you cannot weaponize trivial or technical errors against an employee, especially when those errors were made without a shred of malice or actual knowledge.
So, the absolute crux of this is understanding the legal boundary of material information. In the eyes of the court, material information means highly relevant, outcome-altering facts. Think about it like this. If you are convicted of serious corporate fraud and you hid it, yeah, that's material. But if your name was slapped on some trivial neighborhood dispute complaint years ago that nobody ever even told you about, that is not material in the eyes of the law. If you genuinely do not know about a pending case, making a negative disclosure in good faith shouldn't completely ruin your career.
And honestly, the details of Sagarika's specific situation make this even more wild. Check out this number, 3. Authorities had somehow dug up a total of 3 separate criminal cases registered against her. But here's the kicker. The court found that all 3 of those cases ended in her favor. And even more incredibly, the fact-finding authority confirmed that she genuinely had zero clue about any of them when she handed in her paperwork. 3 total blind spots. None of them involved a conviction. Yet, they almost cost her her entire livelihood. Crazy, right?
So, to see exactly how the court arrived at this really fair decision, we need to kind of zoom out from Sagarika's story and look at the broader legal precedents governing public employment. That brings us to what's widely known in legal circles as the Avtar Singh standard. This is essentially the bedrock precedent. It's the standard that guides almost all modern judicial thinking when it comes to employment background checks and non-disclosure.
Let's map out the ultimate Supreme Court rules that every single employer and judge has to balance. First up, we've got the 2016 Avtar Singh case. This ruling basically demanded fairness. It laid down the law that an employer can't just mechanically fire someone for a typo or a minor omission. They have to objectively weigh the nature, the gravity, and the outcome of the hidden offense. Then, check out the 2021 Raj Kumar case. This is the stricter side of the coin. It says that for disciplined forces, like the police, the mere act of suppression can be enough to get you fired because they require absolute, unwavering integrity. But then, finally, the 2022 Pawan Kumar case swings that pendulum right back toward reason. It ruled that if a case is trivial and the employee genuinely didn't know about it, they shouldn't face penal consequences. Makes perfect sense.
So, taking all of those Supreme Court cases into account, you might be wondering, what exactly is going through an employer's or a judge's mind when they're reviewing some undisclosed issue from your past? How do they take these massive, broad legal standards and apply them to a real person's life? Well, the courts have actually developed a highly specific framework to make sure these decisions aren't just based on, a hiring manager's bad mood.
They essentially run through this exact 6-factor checklist. First, they ask, is the fact material or is it just trivial? Second, did the candidate have actual provable knowledge of the case at the time they filled out the form? Third is the nature and gravity of the offense. Did it involve moral turpitude like theft or fraud, or was it just a minor technicality? Fourth, they look at the final outcome. Obviously, an acquittal looks very different from a conviction. Fifth, if the candidate had disclosed it initially, would it have actually disqualified them from the job? And finally, number 6, they look at the exact nature of the post being applied for.
And that final factor, the nature of the post, it creates this massive contrast in how heavily your background is actually scrutinized. Look at disciplined services. We're talking police, paramilitary, the judiciary. These roles demand the highest possible scrutiny and absolute integrity. If you hide something here, you are way more likely to be terminated, no questions asked. But on the flip side, for general administrative posts, your standard desk jobs, there's standard scrutiny. Courts and employers, for that matter, are generally expected to offer a bit more leniency for minor or technical omissions, as long as they were made in good faith.
Which brings us to our final thought for this explainer. Look, organizations obviously have a legitimate need to vet their candidates. They have to protect their workplaces. But cases like Sagarika Parida's prove that the law still recognizes and actively protects human error. It does leave us with a really lingering question, though. Where do we actually draw the line between an employer's right to absolute disclosure and an employee's right to an honest mistake? As background checks get even more digitized, instantaneous, and just incredibly far-reaching, how are these rules going to adapt to make sure an innocent blind spot doesn't turn into a lifelong career sentence? It is definitely something employers and all of us as future employees need to think really deeply about. Thanks for joining me on this explainer, and keep learning.